Thank you very much for joining us in this session. So my name is Yuemin Yan. I am from the Chinese University of Hong Kong. Together with me, we have Monica Pinto from University of Buenos Aires Law School, and we have Glinder Hernandez from Catholic University of Leuven, and the next is Brian McGarry from Leiden University, and Ben Jurito-Wich from Access Court Chambers. So we have a fascinating panel who will be addressing many of the interesting and topical issues such as Erga omnes, standing interventions, as well as multilateral litigations. So we will not be using the paper presentation mode. Instead, we are trying to organize some roundtable discussions. So our main discussion will last around 35 minutes or 40 minutes, and we want to reserve 20 minutes for Q&A. So if you have any questions, you can just come to the microphone. And in fact, you can come to the microphone if you see the time is close to 4:40 p.m. And so I also want to take this opportunity to thank many people, our organizer and the volunteers, especially Pam, Ballon, and our sponsor, Curtis Law Firm. Thank you very much for having us today and for making this happen. So without further ado, let's move on to our first topic, that is the Erga omnes and the standing issues that is very important in light of the recent case before the International Court of Justice, the Gambia versus Myanmar case. And in that case, it is the ICJ court has recently confirmed the jurisdiction on this case where a party is not specifically affected by the measures taken by the respondent. So we can start from here. Now I want to invite Ben. Could you please give us a very brief introduction, the background, and what's happened there? What is the decision on the jurisdiction by the court?
I'm very happy to perform that informational task, but I do it subject to the caveat that I'm conscious that a great number of people in the room will know it very well, so I'll be very, very brief. The 22nd of July 2022 seems like a long time ago in the world of international law, but that was the date of the preliminary objections judgment in the Gambia against Myanmar. In essence, the Gambia claims that Myanmar is responsible for genocide in respect of the Rohingya people. Myanmar, among many other objections, objected that the Gambia had no standing to bring that claim, and that even if the obligation not to commit genocide is an obligation owed erga omnes and therefore to all other states, in order to bring a case to the court, a case had to be injured or specially affected or specially injured, depending on which version of the various terms one takes from the parties in the court. The court held that the fact that there was an obligation erga omnes partes was enough for the Gambia to have standing and therefore to bring the claim. It's a mistake, I think, to regard this issue as having been novel in the Gambia, Myanmar. It goes back to Belgium, Senegal, and in that case, torture was involved, so there was universal jurisdiction, and the Belgian courts had issued an arrest warrant, and so there was a particular factual link with Belgium. And both the Gambia in its objections and Judge Shui in her dissenting opinion sought to put particular emphasis on those two facts and say that this showed that Belgium-Senegal was not a relevant precedent. A fair reading of it, though, is, in my view, that Belgium-Senegal was already saying that an erga omnes obligation was enough for there to be a case brought just on that basis without the need to be specially affected. But if there was any doubt about that, the doubt has been removed. And so I should stop there because that's just a platform to the real questions I suspect were about to be asked.
Yeah, thanks, Ben, for providing this very important background. And are you saying that in case of erga omnes principles, especially in the Genocide Convention, they would automatically mandate recognition of the standing for all future disputes. I mean, all future disputes raised under the Genocide Convention. And then the court will find, okay, we have the jurisdiction over here, even though the complaint may not be affected directly.
Well, I think that does follow. I'd go even further and say that it's not just that there would be jurisdiction under the Genocide Convention, but that there's no difference in principle between an obligation erga omnes partes, so one owed under a treaty, and an obligation erga omnes owed under customary international law. And that if, first of all, there's a dispute in the sense that the court has characterised that term, if there's jurisdiction, either through compulsory jurisdiction acceptance that matches or otherwise, then that's enough, so long as there's an obligation erga omnes. And so it's not just genocide, but thinking back to Barcelona Traction in 1970, in that case the court listed, and I made a note of it so that I wouldn't forget it. It explained what an obligation erga omnes was, which I won't read out to this audience. And then it said, and we forget this, I think, such obligations derive, for example, in contemporary international law from the outlawing of acts of aggression and of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Of course, that was 1970. Since then, there's also no doubt that self-determination is an obligation, or the recognition of self-determination is an obligation owed erga omnes. So in my view, on the logic of the Gambia, Myanmar, and for that matter, Belgium, Senegal, self-determination, aggression, and other obligations owed erga omnes, even if not erga omnes partes, would also come within this principle, subject to there being jurisdiction and there being a dispute between the parties before the court.
Thank you very much. Glyden, I want to know your opinions on, especially on this decision by the ICJ regarding the erga omnes. Do you agree that for all future cases on Genocide Convention, that the court may establish kinds of standing issues? And besides the examples given by Ben, is there any other, the obligations erga omnes that the court has recognized or that has been the subject matter of the ICJ cases? Thanks.
Well, thank you, Wei Ming. And I think I want to answer your question in two parts.
Yeah.
But the way I'd like to frame it, I think, in listening to Ben, I think this is important. Although, and I agree, that there is no conceptual distinction for establishing jurisdiction between an obligation erga omnes and one erga omnes partes. Of course, given that the consent given is different to the jurisdiction of the court, I think where the real relevance lies is in the question of admissibility. And I think that there is where we find the answer to your question, Yue Ming, in respect of all future disputes under the Genocide Convention. Yes, the court has established that the common interest by virtue of being parties to the convention is to a degree sufficient. It seems to establish a relatively formal understanding of interest for the purpose of basing jurisdiction. But that said, I think we should be careful not to extrapolate from the terms of the Genocide Convention. Other compromissory clauses might include, as does CERD, for example, an obligation to negotiate for 6 months as a precondition, which is an admissibility condition. The Whaling Convention establishes its own regime, and quite possibly we might find other obligations erga omnes that are subject, for example, to the exhaustion of local remedies. This does not add further conditions, but this simply places conditions in respect of admissibility. And those conditions, as we saw in the East Timor judgment, are equally relevant if one seeks to invoke an obligation erga omnes under customary international law. So in that respect, I think we can observe a certain clarification on the part of the court, one that I think has been in the air since the obligation to prosecute or extradite case. But I think we do need to maintain a distinction between jurisdiction and admissibility for the purposes of establishing whether the court will proceed to the merits.
Thank you very much. So regarding, to establish either jurisdiction or admissibility, there should be a threshold over there that sometimes we refer to the terms like interest and injury. So I'm wondering, especially Brian, do you think, how should we understand that, the interest in the context of standing? Is there like particular threshold for interpreting interest, such as its existence, imminence, like significance, etc.? And what is the threshold in the like Gambia and Myanmar case?
Well, thank you, Yuman, and it's excellent to be here. The concept of an interest of a legal nature in the context of intervention we're going to discuss in a few, so I'll hold off on that. With respect to the requirement of an interest for the purpose of invoking state responsibility as the applicant in the case, I would agree with what we've heard so far. With due respect to Judge Sway's dissent, I think that story has been written.
Yes, and Monica, would you like to also elaborate your opinions on that?
Thank you so much. Thank you, Pam and Belen, for convening this panel. My pleasure to be here. Yes, I think that, in fact, when we are dealing with an interest of legal nature, we are just referring to Article 62 of the Statute of the ICJ. And when we are dealing with interventions because you are a party to a convention, to a treaty, and you are interested in the construction of that treaty by the ICJ, you are referring to 63. My reading of the situation is that we are dealing with 63, but in any case, I think that there is some singularity in this case. Just very long ago, in the 1951 advisory opinion, on the reservations on the Genocide Convention, the court went very far. The court said that every state, not only the state parties to the convention, which at that time there were no state parties, the convention had not entered into force at that time, had an interest in the convention to be enforced. So the interest may be there. My reading of the situation is that we will try to speculate on the convention, but I'm pretty persuaded that this is a very singular case. And I can resume saying that the law is back in Europe on the grounds of some fictitious, as Germany put it, claims on genocide, and that is very worrisome. So that's why I think we are finding so much interest states in order to have an intervention in front of the court.
So by saying like this case is particular, are you saying the Gambia versus Myanmar case or the Ukraine?
The Ukraine.
Okay.
The Gambia versus Myanmar case, I think, is sort of opening door, and what Ben and Glader and Brian have flagged regarding that case is, okay, we are dealing and Glader stressed that, we are dealing with Erga omnes rules, we are dealing with use currents rules, but everybody's set of rules has its own requirements, and sometimes we may face different requirements.
Yes, and now the time, everything is changing so fast. And especially, we have some new cases coming. We have the Ukraine versus Russia case here, and now Erga omnes is on the table again. But I would like to know your opinion, especially also like Ben's opinion regarding the approach taken by the ICJ to the Erga omnes. Do you think that the court is taking a more liberal than before, a more narrow interpretation on the scope of the Erga omnes? And the judge Shea has also raised some concerns that in her dissenting opinion, those concerns regard the potential proceedings on common interests, let's say human rights or environment, etc. So Ben, what do you think? What is the current approach by the ICJ on this?
I'd attempt to start answering that by picking up on something Monica just said about the interest of all states in the prevention of genocide. Because in Gambia, Myanmar, one of the points the court made was that if standing was not allowed in a case like Gambia, Myanmar, then there would be many situations where there was a breach, but there was no state who was able to bring a claim, for the very reason that many cases of genocide exist within one state's boundaries. And the whole purpose of the Genocide Convention and other obligations erga omnes, some of which I listed with respect to Barcelona Traction, is that going back to the roots of international human rights law, is that international law does have something to say on that. And here, that's given teeth by the existence of the obligation being enough to allow the bringing of the case. And really what one sees in the dissent and in Myanmar's objections is an effort to reduce the ability of international law to act as a meaningful form of control of behaviour within the boundaries of a state alleged to be responsible for genocide or other acts coming within the erga omnes category. As for the part of your question concerning what are the obligations erga omnes, I think the one that it is useful to concentrate on is self-determination, because there are so many cases where there's a problem interior to the boundaries of a state, where that's neither the people affected nor necessarily the immediately neighbouring states may have an interest or political will in taking the point, but another state from another part of the world may be willing to do so on an erga omnes basis. There's the list that I gave from Barcelona Traction, which I won't repeat, although the reason I read it out is because the existence of aggression in that list is rather notable. But seeking to catalogue obligations erga omnes would take us a bit over our time limit, I think.
Thank you very much. Brian, would you like to add something?
Well, since we've invoked now a few times Judge Sway's dissent, and given the title of this panel, I would like to pose rhetorically, whose dispute is it anyway? I think one of the more interesting aspects of the dissent, bearing in mind how you've characterized, Ben, Myanmar's objections, is this continued focus on the fact that the Organization of Islamic Cooperation had a hand to play here. And I think it's interesting that the court, in its preliminary objections judgment, as well as in its provisional measures order, very specifically says that it was not concerned, legally speaking, with the role of an intergovernmental organization in this respect. I think it's worth querying whether it would take the same tack with regard to the participation, the support of a non-governmental organization or a private party, as one might point out happens, for example, in maritime delimitation cases where one of the parties might be working in consultation or financing with an oil and gas company. So whose dispute is it anyway in that respect?
Yes, Glyden, can you?
Okay, yes. I had another point, but I want to say something about what Brian's just said. And I think it is the extent to which, as much as we as scholars and practitioners like to strategize and think about what might actually be on the court's mind or what might actually be motivating the reasoning, I would be concerned if the court began to depart from its principle of presuming the good faith of a state in front of it. If a state comes before the court and says, we are submitting a claim for this and this and that reason, I do not think that this is a statement that should be taken lightly, and I think the court's decision on the preliminary objections in Gambia and Myanmar is just that. It's a reluctance to peek behind and try to determine whether there's some sort of genuine intention that it can objectively construct that flies in the face of what it's saying. And I think we see this in a number of cases, that this literal or good faith acceptance of what a state is pleading ought not to be taken lightly, and to introduce another way of looking at it would be to introduce a new test, I think. But on your first question, I think, and I'll be very brief on this, you asked if you think that the court is engaging in a more liberal interpretation of obligations erga omnes. I don't actually think so. The court has, in a number of bilateral disputes, identified obligations erga omnes and has been prepared to identify them as such. Tehran hostages, the East Timor judgment, of course, in relation to self-determination, the Wall advisory opinion. Where I do think we're seeing a change, the watershed comes with obligation to prosecute or extradite, and with the Whaling judgment, where the court is prepared to confer standing on the basis of an application of an obligation erga omnes partes. There, perhaps, we're seeing that these are the first cases submitted to the court that allowed it to do so. But more likely, what I would say is that these coincide with the period in which the court began to give way to norms of jus cogens. So starting with the Armed Activities Congo-Rwanda judgment, but also the Kosovo judgment, advisory opinion, and in jurisdictional immunities of the state. That it has become more progressive, I would not argue. That it has dovetailed with developments in the law and that it has reflected those developments, I think, is probably a more accurate way of describing it. And of course, Gambia and Myanmar now enters the pantheon of decisions focusing on these types of norms in our legal order and specifying them, clarifying them for our purposes.
Thank you. Yes.
No, I completely agree with Glader. I think that the international community, the so-called international community, or the ICJ as its voice, if you want, took a time in order to consider these erga omnes or jus cogens rules. And in fact, we started in the 70s, and Ben said so, with the Barcelona Traction. And it took till 1996 in the application of the Genocide Convention for the court to say that the genocide had become, the norm prohibiting genocide is certainly a peremptory norm of international law, jus cogens between brackets. So the time comes in which you are offering the community certain values, and you are those values embodied in legal rules. Well, you have to put some flesh and bones to the enforcement mechanisms. The point here is that I guess it's not in the Gambia, Myanmar, but it is in the Ukraine, Russia, I think, that the flesh and bones comes in a case in which you have an ongoing armed conflict. So that puts two jus cogens rules competing in the same landscape. In the case of the Gambia, Myanmar, what I see is that what Glader said, the court just acknowledges in good faith the presentation of the Gambia, which says, okay, I'm very much involved on that, and I want you to declare that what's going on in Myanmar is genocide. And that's it.
Thank you very much. And also speaking of the erga omnes, it's not just about standing. It may also concern, another very important, concept that is intervention, especially under Article 63 and Article 62 of the ICJ statute. So, Brian, I have this question for you. Do you think, is it possible for third states to have a legal interest as defined in Article 62 of the statute and solely based on an alleged breach of erga omnes obligation? And what is the difference between, Article 63 intervention?
Well, there's a lot to chew off there, so I'll just focus on the first part, Yuman. Thank you. As Ben noted before, with regard to the institution of proceedings, there's no clear difference in principle between obligations erga omnes and obligations erga omnes partes. With regard to intervention, I think one could say the same thing about intervention under Article 62, which is that neither is sufficient. I take a different position than many well-respected luminaries with which everyone in this room would be familiar, but I find it extremely difficult to justify the view that an interest of a legal nature, that term of art within Article 62 of the statute, would be satisfied by an interest in the fulfillment of an obligation erga omnes, and that's essentially for either of two reasons. One is conceptual. The entire raison d'etre for construing the obligation erga omnes in the context of standing as an exception to the traditional requirement of direct injury, that is with us in the international legal order for a very obvious and necessary reason, which is that were it not the case, a state could essentially evade accountability, act with impunity, merely by breaching the most fundamental of norms in a way which does not directly injure any particular state, but rather is an affront to the entire international community. So that would be a perverse outcome, obviously, and that purpose is satisfied as soon as a state institutes a justiciable case against the perpetrator state. It is not furthered at all by adding more states to ongoing proceedings. And I don't think, and this is the second reason, when you look at it historically and in a practice-informed way, I don't think there's any basis to conclude that the drafters of the PCIJ statute where Article 62 was eventually adopted wholesale for the ICJ statute, in 1920 had a view of institutional international adjudication where such that third states would be frequently intervening in cases in which they had no direct interest. So the construction of Article 62 of the statute that the court has, I think, consistently delivered since the 1980s is that it requires a particularized interest which is at odds with the breach of an obligation erga omnes. Now, with respect to, and this will be very brief, Article 63 intervention, it is essentially besides the point. One can look to the very well-meaning and genuine words in the many declarations filed in Ukraine, Russia, concerning the interest that the state has in the breach of and the fulfillment of obligations erga omnes, but legally speaking, that is superfluous. The only interest required is that it be a member of the treaty being construed.
Gladden, can I also have your opinion regarding, the numerous statement of interest in to intervene in the Ukraine and Russia case and from Article 63. Do you think that Article 63 apply to the concept of standing? And if not, what do these numerous statement of interest in the intervention in the Russia case signify about ICJ's objectives in intervention?
I need to be slightly diplomatic here, given that I am acting as counsel for one of the intervening states. So I will proceed with all due caution and speak in a personal capacity. I think it's important, as Brian emphasized, to distinguish between a declaration under Article 63, which concerns the construction of a multilateral convention where there are notifications made by the court, so the court is actively contacting state parties, versus the intervention process under Article 62, which connotes a higher degree of legal interest, which we see through the practice of the court. And I think Brian's the world's leading expert, at least for now, on this point. So I will leave you to answer this. But I think we really must not confuse interest of a legal nature within Article 62 with anything in the wording of Article 63. But before I cede the floor, I actually want to ask Brian a question with respect to this particularized interest point that you've raised. And I'd be really interested, just as a thought experiment, it occurred to me that states declaring that they might intervene in Gambia, Myanmar, could now particularize their interest simply by filing another dispute against Myanmar in their own name as a party, couldn't they? And that would be an entirely different proceeding, but they could nevertheless seize the court, provided that they can establish a sufficient interest and the existence of a dispute to found the jurisdiction of the court. And then maybe the court decides to join them. And we have, I wouldn't say we have the same outcome. In fact, we don't at all. But we do have these numerous voices coming to the court. And I'd be interested in your views on that.
Thanks, Glider. I'll be very brief. I would agree with you that having a particularized interest coupled with a basis of jurisdiction is, of course, sufficient to institute new proceedings, and it's not only sufficient for intervention under Article 62 of the statute as it's been practiced, it is moreover sufficient for Article 62 intervention as a party, which has been hypothesized by the court but has never happened, and which could happen, of course, in a genocide convention case by virtue of the fact that the applicable law concerned is also the basis of jurisdiction.
Yes, Monica.
No, yes, perhaps to jump with one of the issues that is mentioned in the title of our panel, there may be a trend to read Article 62 of the ICJ statute as most concerned with bilateral issues, with disputes in the more classical scope of the notion, and just as Glader said, a high degree of legal interest in order to avoid having to conclude as in monetary gold. And on the other side, interventions in Article 63, which I do agree with Brian, when it was drafted in 1920, perhaps they were not thinking on this, even though I must say that some idea of jus cogens and erga omnes can be traced back to that period. Article 63 may focus more on the multilateral interest in the situation. The point that we are raising erga omnes and jus cogens issues is something that should concern the whole community of states. And so I think that's perhaps the way of getting into the multilateral aspect of our panel.
Yeah, thank you. So we have like mass intervention in the Ukraine case. And now the Netherlands and Canada have showed their intention to intervene in the Gambia case. So Ben, I would like to know your perspective on that. Do you think the court would admit interventions in the Gambia case as it does in the Ukraine and versus Russia case? And why would the court switch its position? Because historically the ICJ has been cautious admitting interventions.
It's quite hard to have a round table on a rectangular table.
Yes, it is.
And so before I get to that, I might just react to something Brian said a moment ago about Article 62 intervention. I understood him to say that although Article 62 requires an interest of a legal nature, having an obligation erga omnes would not be enough. So it would be enough in Gambia, Myanmar, for it to be standing for the applicant state, but it would not be enough then for another state to apply to intervene under Article 62 with effectively the same position as the Gambia. And I'd just like to probe that a little bit because the words of Barcelona Traction on erga omnes are interest of a legal nature. I appreciate that's a different context, but to bring in effectively a specially affected test into Article 62 seems to me to minimise the importance of the obligation being erga omnes in the first place. Because if the test is there an interest of a legal nature, and the obligations erga omnes and therefore owed as between all the different states, if a state, in addition to the applicant state, wishes to intervene. I entirely take the point that there might be a question about the utility of that, and there might be a case management question about it, and there could be questions about whether it's desirable in general. But so far as it being, in principle, admissible under Article 62 as constituting an interest of a legal nature, for my part, I don't see the difference between an applicant state and a state seeking to intervene under Article 62. So you mean with your permission, we might just have a round table on that point before I have a go at your question?
Yes.
Yeah.
I can be very quick. Yeah. Thank you, Ben. Like I said, I'm going to catch some flack for this, and I'm sure my book reviewers will do the same. But for the reasons I gave earlier, I do not see any sound basis to analogize between the customary requirements for the institution of proceedings and the statutory requirements for intervention in those ongoing proceedings. I'm in the camp of Judge Keith, who said in the Nicaragua-Colombia case that he criticized reference in intervention practice to that very dictum from Barcelona Traction regarding obligations erga omnes. In his view, the latter related to the rights of states to bring claims rather than to the substantive character of the right or interest, a matter apparently distinct from the, quote, interest of a legal nature to be assessed in determining a request for intervention. So references in the court's 1970 judgment to a legal interest in the fulfillment of obligations erga omnes, I think make a lot of sense colloquially as basic English, but legally speaking, I see very strong ground to distinguish them.
Well, there's been so many panels where there's been furious agreement. It's nice that we have a panel where there's some disagreement.
I'm happy to help.
Glenn.
On that, though, I will try to reconcile my dear colleagues to the right, sorry. But is this not simply a question of legal argument and strategy? In the sense that, provided that an intervening state sufficiently ties its intervention to the dispute as invoked by the applicant, then the particularized interest is respected, and there's no necessary reason to impose a more substantive test or threshold. However, an intervening state that makes no reference to the manner in which the applicant has brought the dispute, that seeks to invoke an entirely different set of relevant facts or arguments, would not then meet the sufficient interest in that dispute. It is not so much a question of the facts at hand. The facts would be the same. X human rights situation, X grave atrocity in this physical territory. Fine. But does it not hinge on the manner in which the intervening state presents its statement? And I think it is there that we find some middle ground between what both of you are saying. You are suggesting that nothing in principle excludes a well-reasoned argument, and you are suggesting a particularized interest in that dispute as it has become bilateralized is relevant. That's how I would read your things. Sorry to reconcile.
I'm not sure you have reconciled. There's a lot, I think, that needs to be thought about in the word legal. It's an interest of a legal nature, but I don't want to hog the rectangular table.
Yes, Monica, do you want to?
No, it's okay.
Okay. You have so much for, a lot of, the Article 62 and 63 intervention, like the substance. Now I want to ask Brian and Monica as well about, some procedure-related aspect in terms of intervention. So has there been any principle that prevents intervention at the stage of preliminary objections? And additionally, how should the states and the court navigate, this complexity, especially concerning the issues at stake during this stage? Yeah, perhaps Brian, could you? Yes.
Would you like to go first?
Okay.
Yeah.
Thank you. Okay. I think there is no obstacle preventing a state to try to intervene under Article 63 at this time in the jurisdiction phase. At least there is no written rule saying so, and so I guess that the court has full discretion to do so. The point may come in some of the declarations that have been filed that states mix arguments regarding jurisdiction and regarding the merits. So the court has said in the Whaling case that, in fact, Article 63 is a right, but that doesn't mean that ipso facto you can get into the file. There are admissibility or sort of admissibility. The court doesn't use the word admissibility, but I guess that when faced with declarations of intervention having to deal with both things, the court will have to take a decision on that. The decision may be just to postpone the issues on the merits for later treatment. The explanation on which we can ground a decision like that may be what the court said in the case of the military and paramilitary activities in and against Nicaragua and El Salvador, but it was arguing under Article 62, decided to jump into the case, and the court said, okay, what El Salvador is raising is not pertinent to this phase of the proceedings. But that's all what we have, and that was a case in which the case should have been under the UN Charter, and for all the reasons we know, the US reservation and so forth, the court decided on the grounds of customary law.
I think that's an excellent segue. Thank you, Monica. In the Nicaragua case, where El Salvador's declaration under 63 was deferred by the court and ultimately dismissed for the reasons that you just summarized, I think probably Judge Nagendra Singh in that case was the first to put forward the idea that while he agreed with the court in that instance, had El Salvador restricted the scope, the subject matter of its purported intervention to questions of jurisdiction, then he would have seen no principled basis to defer and to impede that right of intervention as the statute refers to it. So this raises an interesting question in the context of the Ukraine-Russia case that's probably on many of our audience members' minds, where we have this diversity of content in the dozens of declarations filed. Mm-hmm. We have among those declarations those such as Germany, which seem to have heeded Judge Nagendra Singh's advice and restricted their subject matter to questions solely of jurisdiction. We have the United Kingdom, which has very interestingly hedged for both possibilities of a solely jurisdiction-based intervention and one connected to the merits. And obviously, since many of those declarations have been filed, the preliminary objections phase in that case has begun. So this raises the question whether for the rest of these declarants, There is a doctrine of severability where the court can go into some of those declarations and say, you're allowed to participate at this phase during the preliminary objections phase solely in respect of questions of jurisdiction, just like the parties. Obviously, whose dispute is it anyway? It's certainly more the parties than the non-parties, and we can't allow non-parties to be talking about merits questions when the parties themselves have been told to hold back. I think perhaps the most interesting precedent on this point is actually in Article 62 doctrine, and that is in the very first case in which there was a successful Article 62 application, the Gulf of Fonseca dispute between El Salvador and Honduras. Nicaragua had put forward a number of potential interests of a legal nature and bases which the court found to be beyond the scope of permissible intervention in that case, but it was permitted to intervene on some of those bases. So we do have some practice from the court's intervention doctrine showing that there is perhaps some kind of doctrine of severability where it will go in and take what it needs.
Thank you very much. Before I ask another question, I want to give a kind reminder that if you have any questions, please come to the microphone, that we are actually now in the Q&A session. Yes, please? No, please.
No, you had another question.
No, now it's the Q&A. Yes, please.
I mean, I'm following your invitation.
Okay, then thank you
I'm
very
not
much.
taking the
In
floor
fact,
from you.
I think so based on all this discussion, I'm really wondering, what is the attitude of the ICJ? Is ICJ really happy with all these, interventions? And so I really want to know, because also for Article 63, there is a notification to, the parties to the convention. When would, the ICJ would give out this notification and then to involve as many interventions or to avoid this kind of interventions from the convention parties? I really want to know the opinions from all our panelists. Yep, perhaps we can begin.
In fact, I don't know. We have to put the question to the court. But a first inference may be that if ever the court had been decided to reject the interventions, it could have taken care of the first and second declarations and got rid of them. The point is that declarations are filed, the registrar is notifying the parties, is putting that in the website, and we are following this issue. So I think that we have to wait for the court's decision, but I don't think that there is a pre-established decision just to reject the interventions. On the other side, and that may sound very much naive, in a certain way, we are here also because of the court. My personal reading of international law is that we are here and we are dealing with international law rules because the states have put together those rules. But at the same time, the court has led us to have Erga omnes rules, to have jus cogens rules, and at the same time, states are expected to try to enforce those Erga omnes and jus cogens rules. So perhaps the moment has come for the court to say, and we can infer that from the decision in the Gambia Myanmar case, and also in the lines, among the lines of the Ukraine-Russia case, that the court is just expecting, it's just making room for this enforcement to take place.
Yeah, thank you, Glendon. And on that, I want to push a little bit more. How much weight do you think the court would give to these interventions? Thank you.
I will be careful in what I say. I think trying to psychoanalyze the court is an exercise akin to inviting a state into a psychologist's office to ask it to tell us how it really feels about opinio juris. In other words, not very useful. However, the little we can do is occasionally divine from the speeches to the General Assembly by the President of the Court about how the court is feeling about certain issues. And sometimes it intimates in its judgments like Southwest Africa or Icelandic fisheries, where it feels its judicial function, whether as the principal judicial organ of the UN or as a device for dispute settlement between states, is being pushed to certain boundaries. I think besides that, we're not going to get very far as scholars and practitioners, besides the gossip that we can all pick up from time to time. On that basis, I feel really uncomfortable saying what I think the court might do or might not do in respect of these interventions. The scholar in me suggests that what we need to look at is the court's settled practice and the manner in which it interprets attempts by states to seize the court or to draw attention to the court to certain issues. I think well-constructed arguments will be received well. Poorly constructed arguments will be dismissed or redrafted. This was a similar discussion we were having in respect of the advisory function yesterday in an excellent panel. We need to be careful in distinguishing the sociological aspects of what the court might do, so the material aspects, from the formal aspects of what the court can do. I suspect it will hew very close to its settled practice when possible. And I'd rather not say any more.
Thank you very much. Brian?
How should the court weigh the content of the interventions that it receives under Article 63 in the present Ukraine-Russia case? Probably much the same as in advisory opinions, perhaps in a more classical Article 63 case. Nevertheless, I would agree very much with what Glider said. The whole purpose of Article 63 intervention is treaty interpretation, and so legal argumentation in the abstract in that sense is going to be what the court will take from the intervention. Article 62 intervention, on the other hand, at least in my view, which I've already clarified is not everyone's view, it's not on the basis of brilliant legal argumentation. It's on the basis of essentially stay off my lawn in a territorial dispute, or perhaps in the jurisdictional immunities case between Italy and Germany, where Greece intervened on the basis of the interest of its judiciary. There's something, as I said, I think particularized about it, which the court has to take in a slightly different weight, to use your word, than in abstract legal reasoning based on treaty interpretation and under Article 63.
Yes, Ben, could you conclude this question?
I don't think the question is whether or not the court is happy, or for that matter sad, about all the interventions. I think the issue is a practical one of case management. The question is, how will the court manage them? And the court has tools to do that, which it's using. But I'll stop because I'm keen to hear what the audience has to say.
Yes, I think we have a question. Yes, please. Please introduce yourself.
Thank you. Then I take the floor now. Pierre D'Argent from Louvain University, also special counsel to Erga, and one of the counsel and advocates of the Gambia in the Gambia-Myanmar case, having been tasked by the Gambia team to argue this standing point, both in the provisional measures and the preliminary objections. Now, I think Ben made a very important point. You need to have a dispute, okay? The dispute is always a bilateral matter. And you can have a dispute between two states because you are entitled to invoke the responsibility. And the specificity of Erga omnes or Erga omnes partes obligations is that in any given case, you can invoke responsibility. The words "in any given case" are present in the judgment of Gambia-Myanmar. They are present in the Belgian-Senegal case, and those words come from the resolution of the Institute where Special Rapporteur Gaia, before he became a judge, was the rapporteur at the Institute on Erga omnes obligations. So the specificity is this: in any given case, you can invoke responsibility. If from that invocation of responsibility a bilateral dispute arises, then if there is jurisdiction, because you have a jurisdictional clause, you can go to court, you can seize, and you have jurisdiction. The requirement of a dispute is jurisdictional both from a statutory point of view, the court has said it, and also from the point of view of the treaty provision at stake, the compromissory clause. But once you have a bilateral dispute, the beauty of Erga omnes obligations, and you can have that bilateral dispute between states who have nothing, there's no specially affected or injured state, then you can seize, and that's the lesson we learned from the judgment. In the provisional measures phase, the Myanmar argued and conceded that the Gambia would be entitled or was entitled to invoke the responsibility of Myanmar, but that would not be sufficient to bring a case before the court. And the court rejected that and confirmed this rejection in the judgment on preliminary objections. Now, I would like to settle the fight between Brian and Ben, or the disagreement between Brian and Ben, because the words of 62 are not only an interest of a legal nature, and I fully agree with you, Ben, that looking at those words, of course they include erga omnes, but the sentence continues. And this is a requirement of admissibility under Article 62, an interest of a legal nature which may be affected by the decision in the case. And this is what is needed. This is the requirement that you have to show. This is the test that you have to meet in order to be admissible under Article 62. And there, the question for us is to think whether, by definition, if an erga omnes obligation is at stake, then the decision of the court is likely to affect the interest of any state. And that I'm not sure of. And that is why I think I agree with you, Ben, that the words interest of a legal nature can encompass erga omnes obligations, but I agree with you, Brian, that because the sentence does not stop there, there is a requirement of particularization under 62, which, in my opinion, would be an obstacle for many states. Now, it doesn't mean that you cannot bring another dispute. Fully agreed. If there is a dispute, you have created the dispute bilaterally, you can bring it to the court. And finally, 63, and Glider is my comrade in this intervention. I think the only requirement is that you are party to the statute and party to the multilateral treaty that is disputed before the court. For the rest, erga omnes or not erga omnes, this is absolutely irrelevant. The fact of the matter is that because there is an erga omnes obligation at stake in the Ukraine-Russia case, states are politically incentivized to intervene. But legally speaking, it is entirely irrelevant. Thank you.
Can we collect more questions before the panelists can address? Is there any other questions? Okay, while we wait, let me invite our panelists to address this comment.
Well, Pierre, thank you very much indeed. Two aspects of that I'd like to make brief comment on. One is in any given case, and the idea that disputes are bilateral. I agree with that, and I think it followed from something that you later said, that you accept that although disputes are bilateral, there can be multiple bilateral disputes. And what the difference between multiple bilateral disputes and a multilateral dispute is might not mean anything in practice, but there needs to be a dispute, and I think we agree that that's crucial. On the interesting question of Article 62, in a sense, this entire discussion is premature because the court's practice on intervention is so underdeveloped and it's about to become, in an awful hurry, quite developed indeed. And so it will be very interesting to see what happens. While it's true that the sentence goes on to say, which may be affected, important word, by the decision in the case, what does the which refer to? It's the interest of a legal nature. It's not that the state needs to be specially affected, it's that the interest of a legal nature is affected. Sure, it's for those who didn't hear Pierre, the table is getting rounder. He said that it is the interest of a legal nature has to be an interest of a state. That's true, but it's still an interest of a legal nature that needs to be affected. But we could debate it for a long time, and I'm keen to hear what Brian has to say.
Thanks, Ben. I agree. It's a very interesting argument that Pierre has put forward. I don't know that I even though he comes to the same conclusion as I don't know that I would use that causal clause in Article 62 to make that point, because it is potentially debatable, as Ben has pointed out. But I do take your reference to the work at the Institute from Judge Gaia, who is one of those extremely well-respected people who disagree on this point with what I've just put forward here. In his Hague Academy course as well, he referred to the idea that there's no way that an interest required for Article 62 intervention should be higher than the threshold required to institute a case in itself. And my view is simply that that kind of rhetoric of higher or lower is a really awkward fit for the history and practice of intervention. And you could draw, I think, a contrast here to perhaps the most multilateral of interstate dispute settlement institutions, the WTO, where the required interest for intervention is a substantial interest under Article 10 of the DSU. That is an interest of degree, as opposed to what we have in the statute of the court, which is a kind of interest, a legal interest, in my view. Thank you.
Yes, if you have any question, please feel free to come to the microphone. And I think I also want to yes, please.
Yeah, hi. I'm wondering whether you see any prospect for joined-up interventions, which is certainly, if you look at U.S. Supreme Court practice, for example, amicus curiae briefs are frequently signed on by multiple groups that it carries political weight as well as legal weight. Is there any prospect, and do you see any room in procedure for states to join together in interventions and present a common legal position to the court?
Yeah.
I'll take that, I suppose. It's relatively straightforward. I think Canada and the Netherlands have filed a joint intervention. And I think that's the way the court will treat that question will settle the dispute. Interestingly there, I just want to point out that Canada and the Netherlands are also involved in a rather less mediatized situation. But in 2020, they made a joint declaration calling upon Syria to cease its breach of its obligations under the Torture Convention, specifically mentioning the time of 6 months and reserving for themselves the right to take a dispute further, which fulfills exactly the compromissory clause in the Convention Against Torture. Now, they haven't followed up on it yet, but I think it's indicative of the formal possibility of these things to happen. And I just have one sentence to add to something that Brian was saying about the substantial test in WTO law. I wonder if a way to think about this is whether a legal interest is of a formal nature or of a material nature, and that one way to understand Article 63 is that it is purely formal, or rather more formal, and that the extent to which an obligation erga omnes is involved dispenses with the formality test if one goes for an Article 62 intervention. I don't know what you think about that.
Over drinks.
On the question about joint intervention, I think it goes back to your question, you mean, about what would make the court happy. We're yet to see how the court deals with a joint intervention, but my own view would be that in principle, that would make the court very happy because it means less interventions and more coordination and cooperation, which means less pages to read and less arguments to consider. So I think in practice, it's a very good idea.
Thank you very much. Please, could you introduce yourself?
Of course. Celine Brown, University of Ottawa. I have a question that might be either very hard or very easy, and it relates to Article 63. We heard that for Article 63 to apply, we need an abstract construction of the Genocide Convention, and I was really interested in hearing whether the panel thinks that the states succeeded in this balancing act between making meaningful statements on interpretation while not venturing into the facts of the case too much.
Monica? Okay. Anyone would like to?
I'm very sorry with a minute and a half left that I didn't fully hear the question.
I couldn't hear it either.
Yuman, could you briefly paraphrase?
I couldn't hear it either.
I think I heard the question, which was, did the states succeed in the balancing act of putting forward a construction of the convention to come within the terms of Article 63 while still being useful and meaningful? Is that a fair summary?
It's good, yeah. Sorry, maybe I was too close to the microphone. It's about whether the balancing act between facts and abstract construction was struck right by the states.
Well, thank you very much for the question. All I can say is there's such a diversity among the dozens of declarations and the different approaches that I'm not sure any of us up here are well positioned to prejudice the court's answer to your question.
Yeah, more or less the same. Thank you. I only had the same problem. No, I think I do agree with Brian. Declarations that have been filed are more or less homogeneous regarding Article 9 in the fact that they lead to Article 9, but the way of putting things is not homogeneous at all. So let's see what happens.
Okay. No. Thank you very much. I think we are in a very good time management. It's the end of our session now, and I want to thank you all for joining us in this wonderful discussion. I want to thank our panelists as well as our organizer Pam and Balin. Thank you very much, and see you around.
Thank you.